G'day guys. Right, part 2 of the $60 parking ticket saga. As I said in part 1, I'll read you out this ticket. Now, it states here it's a stationary vehicle offence infringement notice. So it's a notice, it's not a fine. Enforcement authority is Auckland Transport, and it's to the user or person entitled to possession of, or the person registered under Part 17 of the Land Transport Act in respect of the vehicle described below. So it's to the registered owner. This infringement fee is payable within 28 days after service of this notice. Is it? If I naturally think I'm presumed guilty of everything, then sure. It's addressed to capitis diminutio minima, in other words, just the capitalised initials, the rest is all in lowercase, so it's addressed to my natural person. And it states here on the 12th of October at 3:44 PM on Friday, notice number 3066243-825, registration plate FAN 394. It's got my date of birth here. I'm interested to see how they figured that out, because I was there and I don't remember my date of birth. I was busy being born at the time. Officer number 1126, the cowardly little guy that likes to hide in concoves and take photographs from 10 metres away. Its type here is a motor vehicle. Incorrect, it's a private motor car. Make is Mitsubishi. Street is Ratanui Street. Unfortunately, they can't write down 7, which is where it was parked. Suburb Henderson, side of street, blank. Locality, opposite Harvey Norman's. Distance from sign, blank. Rear, blank. Restriction, blank. Meter number, blank. Start date is the 12th of October. End date is the 12th of October. Start time is 15:41. And yet the time of the offence here is 3:44, so the start time is 3 minutes before they issued the infringement, and the end time is 15:41 and 54 seconds. So for 54 seconds is what this ticket is for, even though it's a parking 90 spot. Offences, or the offence specify, parked in an area marked by broken yellow line. Land Transport Act 1990, Section 40, and Offences and Penalties Regulations 1990, Rule 4 and 6.4, Subsection 4 of Road User Rules 2004. So that's where the offence is created, because they're informing you what section of what act it's allegedly breached. Tells you the penalty infringement fee is $60, towage fee is $0. I would have loved to have seen them try towing it, considering, people were there the entire time watching the vehicle. And of course they give you this little remittance advice at the bottom, which is basically just a check. You're paying them twice by doing that. And people say, why challenge the spigot? Why the fuck not? Do any people out there not believe they're innocent until proven guilty? Then why pay something that says you're guilty of something without them proving it? It's that fucking simple. To quote Mike McMurtry from the $80 speeding camera ticket, Your Honour, nobody ever questions, everybody just pays. Okay? So if you want to live in a society where everybody just shuts the fuck up, pays because they naturally think they're guilty of everything, have at it. Myself, unlike most of the ignorant fuckers out there, actually, I've done my studies, I know my rules, I know the laws, and I know what my rights are, and I know Section 25C of the Bill of Rights gives everyone the right to be presumed innocent. It also says that you don't have to confess guilt, and you can't be compelled to confess guilt, which is an important thing to remember when I show you something else that Auckland Transport also get you to do. So, on the back of the thing, it's of course at the bottom of the remittance advice here, it says, important, please read the information printed on the back of this form. It's important. Information. If there is anything in these notes you do not understand, you should consult a lawyer. Reason being is because it's written in a completely different language and lawyers are trained to understand legalese. You aren't. Payment. If you pay the infringement fee, including any towing fees, within 28 days after the service of this notice, no further enforcement action will be taken against you. You got that, use? Bah! No more enforcement action will be taken against the you if the you just shuts up and pays. Defence. You will have a complete defence against proceedings related to the alleged offence in this infringement or in the infringement fee, including any towing fees, is paid to the enforcement authority and received at the address shown on the notice within 28 days. So they're saying if you pay, you'll have a complete defence. 3. Late payment or payment made to any other address will not constitute a defence. How are you defending something by just paying? In respect to the alleged offence. Again, it's an alleged offence. Nothing's proven until, and they say liable. Liable means upon conviction. So you are liable upon conviction to pay the fee. Until such time you are presumed innocent, the allegation must be proven because it is a Schedule 1 criminal offence. The burden of proof for a criminal statute or a criminal offence is beyond reasonable doubt. It is not a civil matter where it is just a preponderance of evidence. It is beyond reasonable doubt. So they have to prove beyond reasonable doubt that my person or me parked that vehicle there. Going to be a bit difficult for them. Further action. 4. You must write to the enforcement authority if you wish to do any of the following things. Must I? A. Raise a matter concerning the circumstances of the alleged offence for consideration by an enforcement. So in other words, beg to please get let off something that you're not guilty of in the first place. Or B. Deny liability. You're not liable until conviction, so there's nothing to deny. It's that simple. They have to prove it. You don't have to deny shit. Deny liability for the alleged offence and request a court hearing. Okay? We've done that before, haven't we, kids? C. Admit liability to the offence. See, so they need someone to confess. But you can't be compelled to confess. But wish to have the court consider submissions as to the penalty or otherwise in your letter, must request a court hearing, admit liability in respect of the offence, and set out the submissions that you would like the court to consider. So, in your letter, you must request a hearing, admit liability. So they're telling you you must confess in your letter if you're requesting a court hearing. Why the fuck would you? You have the right to remain silent. They have the burden to prove everything. Do you see how the wording in these letters can lead people just to naturally confess guilt without even knowing it? You must ensure that your request is received on or before the last date for payment, which was the 12th of November. If you deny liability and request a court hearing, so here you're denying liability and requesting a court hearing. See, the trick is you don't deny or refuse anything because that means you have first-hand knowledge. You just shut the fuck up. You say, the whole trick is to stay in honour, okay? You don't want to deny, cause controversy in any way, shape or form. In fact, by staying in honour, what you want to do is accept their claim, provided they can establish evidence to support their allegation. That way you're staying in honour, you're not refusing or denying anything. Denying means not true. And therefore the burden of proof still lies on them. They're the one making the allegation or the claim. They must prove it. It is not for you to help them prosecute you. If you denied liability and request a court hearing, the enforcement authority will then, if it decides to commence court proceedings, so it's an if there, in respect of the alleged offence, serve you with a notice of hearing setting out the place and time at which the matter will be heard by the court. If you admit liability, in other words confess, but wish to have the court consider submissions, the enforcement authority will then, if it decides to commence court proceedings in respect of the, now it's an offence, not alleged offence, file your letter with the court. You are not entitled to make oral submissions to the court. Oh really? Well, what do you think a preliminary hearing is? They're asking you to state one of three things: guilty, not guilty, or enter a special plea. Those are your three options. You don't get to plead innocent. Okay? Now, to make a plea of guilty or not guilty or enter a special plea, you must fully and fairly be informed of the cause and nature of the allegation. You must be informed of everything. You must have initial disclosure. They might say Section 12.3 of the Criminal Disclosure Act 2008 absolves them of supplying initial disclosure to Category 1 summary offences, which is a speeding ticket or a parking ticket, but then if they don't give you initial disclosure, you haven't been fully and fairly informed. So how can you honestly, willingly, knowingly enter a plea if you haven't been informed of what the fuck you're there for in the first place? It's real simple. If you haven't seen the evidence against you, you know, I've gone online, I've seen the two photos that are associated with that plate number linking to my private motor car, and it just shows the car photographed from 10 metres away on a rainy day with wet surfaces, no yellow lines, and it doesn't show the person that parked it there. Now, they can't go and get the money out of the car, can they? They have to get it out of the registered owner. But what happens if there's more than one registered owner? Now, Section 133 of the Land Transport Act will state that the registered owner or owners, plural, so it doesn't matter if you're multiple owners of the vehicle, you're considered to all be driving at the same time, and therefore you are all presumed guilty of any alleged offence. So how can you be presumed in the Land Transport Act to be guilty of an offence, and yet in the Bill of Rights Act be presumed to be innocent of any allegation? Bit of a conflict there, isn't there? It's because it's all under presumption. Because everybody just pays, nobody ever questions, it just carries on. And everybody's feeding the coffers of the politicians by being dumb, ignorant fuckers, just trying to work their days, just trying to keep food on the table and keep a roof over their head. Because everybody's so wrapped up being a fucking tax slave these days, they've forgotten who they are, what capacities you can be, and what your rights are. And I'm sure you've probably heard this from me before, but at the end of the day, it just needs to be drilled in home. I'd like to say it with some comedy, you know, have a chuckle. People tend to take things in more when it's said with a bit of humour. Don't believe me? Go and watch George Carlin. You are not entitled to make oral submissions to the court. If the court finds you guilty or you make submissions, costs will be imposed in addition to any penalty. Court costs about $30 on a $60 ticket. And those court costs will be dismissed once the charge is dismissed, because they ain't winning this one. Information for owner of vehicle or registered person, presumed actions and defence. Keyword, presumed. Read and listen closely. 5. If you are the owner of the vehicle involved in the alleged offence, or if you are registered in respect of the vehicle, whether or not you were the driver, person in charge, or user. Use means it's a commercial term. You can either use the roads or you can access the common way. It's all in the words. Or user of the vehicle at the time of the alleged offence, proceedings may be taken against you. In those proceedings, the actions of the person who allegedly committed the offence are presumed to be your actions. But you can establish a defence by proving, really? Defence does not have to prove jack shit. By proving, for example, that the alleged offence was committed by someone other than yourself. See Section 133A of the Land Transport Act 1998. This is where they tell you, if you weren't the driver, and if you want to transfer liability, even though you're not liable until you're convicted, if you want to transfer liability, then you've got to fill out a declaration stating that you weren't the driver and give the details of who the driver was. Therefore, you have a signed declaration which will stand up in a court of law that it was the other person driving, you're off the hook, and then they can go after them because now they've got evidence of a signed declaration stating it was them driving. Or because in section 133A of the Land Transport Act, it states if you choose to make a defence in that fashion, it's not something you must do. And this is one of the crunch points of the $80 ticket. They were trying to say, I must. It's the law that says I must fill out a statutory declaration if I wasn't the owner. The only thing I must do is shut the fuck up and ask them what evidence they have that the person alleged to have been the defendant or the offender is the driver. What evidence do they have? It's not for me to prove a defence. It's for them to prove the allegation. It's for you to ask questions to satisfy it so you can then accept their claim and stay in honour. If they can't provide the evidence, you're still in honour and they just can't support their allegation. And it's all using section 133 of the Land Transport Act that you are presumed the driver. You are presumed guilty. Okay? This is how they get it. This is how they win every time, because nobody bothers. You know, you could say, oh, I wasn't parked there, I didn't park it there, I parked it up the road a bit. You're still admitting to being the driver. You could say, oh, I wasn't going that fast, I was only doing, 84. You were still admitting to driving. By shutting up and saying, what evidence do you have that I was the driver? And asking questions. And they can't prove it. Guess who wins? You do. Okay. Next steps. If you do not request a hearing and do not pay the infringement fee, including any towing fees, within 28 days after service of this notice, a reminder notice may be sent to you. No, a reminder notice must be sent to you. It's step 2 of the statutory offences, and I think it's Summary Offences Act 1957, section 21. Tells how all of those offences should be handled. Step 2 of section 21 states that a reminder notice must be sent. So you may doesn't cut it. You should and will be sent a reminder notice. As far as speeding tickets are concerned, you really need that reminder notice, because on the original ticket they don't even label what the offence is. They don't give you the provisions of what legislation you've breached. They just give you a description. So they're not actually even creating an offence on the initial speeding ticket. It's just a notice to let all the sheep just shut up and pay because no one questions. A reminder notice will be sent to you. Please note that in some circumstances, if you do not receive a reminder notice, you may still become liable to pay a fine and costs and court costs. Well, not if you explain that to the judge that you never got a reminder notice, because again, it's for them to do their shit properly. It's not for you to go chasing up someone else's allegation against you. It's for you to shut the fuck up and ask them for evidence. Note, all payments, queries and correspondence regarding this infringement notice must be directed to the enforcement authority at the address shown on this notice. When writing, please include the date of the alleged infringement offence, the vehicle registration number shown on this form, and your address for replies. Correspondence through websites www.at.govt.nz/query. So you can go to that website, and I'm going to show you what's on that website. They give you two options. You can fill out an online form where they get you to confess. Okay, either way they give you here at this website to either do it online or to print out their little 4-page how to request a court hearing document. And both options, a mandatory question is I was the driver or I wasn't the driver. They're getting you to confess in the application for a court hearing. Okay? So, again, you can't be compelled to state whether you were the driver or not. You cannot be compelled to confess guilt. So by them doing that, they're tricking you again. The only way to correctly do this is to write a letter of your own device and send it in, and you're going to see exactly how I did it and what I sent into them in a second after I finish reading all this crap. Written correspondence to Auckland Transport Parking Review, Private Bag 92260, Auckland 1142, or by phone 09 355 355 3. I will be ringing that number because I'm going to ask them if they've got an email address. Because in this day and age, surely they've got email correspondence. So that's the ticket and what's on the back. And as I was saying, it's all presumption. Alright? And they want you to assume. To presume means you can be in error. You can presume there's unicorns without evidence. You can presume anything you like. To assume something, you're assuming responsibility or liability for, because you're making an ass out of yourself, basically. You're assuming after the facts have been placed to you. Okay? So that's the difference between presumption and assumption. So, I'll show you here what the website says. And you can see quite clearly on that website where it says, or it's got a little asterisk there stating to confess whether or not you were the driver or not. And on the court hearing request form here, your options, it tells you how helpful of Auckland Transport, the people bringing the charge, to give you the information that you need so they can fuck you up good and proper. This basically just tells you all of the same crap that it did before, but we'll have a quick look at it. 1. Pay the infringement fee without any additional charges. If you accept that you are guilty and pay the infringement fee before the notice is lodged at court, no further action or additional court administration of the hearing costs will be incurred. Please turn to the back of this brochure for easy ways to pay. In other words, shut up and pay. 2. Send a written submission to the district court. Sending a written submission means that you do not appear in court. Well, that's where the word appearance comes into place. An appearance, legally, can be a written novation or memorandum to the court. It has nothing to do with you, the meat popsicle for the name, showing up in a building anywhere. An appearance is simply a piece of paper that you do not have to appear in court. This option is only the only one available to you if you wish to plead guilty but feel you have good reasons that may excuse you. In other words, you're going and asking mummy and daddy, please let me off the ticket, even though I did it. Oh my God, government are there to serve the public. The public are not there to answer to the government. Your written submission and any previous correspondence you may have sent will be forwarded to the court on your behalf. Fucking brilliant. If you have additional supporting evidence, include with your request for submission and hearing. Justices of the Peace will consider your submission in chambers and you will be notified of their decision by mail. Okay, so you don't actually even get a court hearing, you just write a written submission, they decide in the closed chamber, in their little star chambers, and notice it's Justice of the Peace, because Justices of the Peace can only preside over Schedule 1 offences. Even though in the Court Matters Bill, they're trying to give Justice of the Peace's abilities to preside over Schedule 2 offences, which they're not trained or have any clue enough to handle. So, this is why you will always see just a Justice of the Peace for a parking ticket or a speeding ticket. It's a Schedule 1 offence. You don't have to be in front of a judge. Unless you go and pick a fight with them and say, I want to record the thing, and next thing you know, you're slammed on a judge's list. Hey Tim, you criminal. Only the person in possession of the vehicle may request a written submission. Really? So what if two people possess the vehicle? Please post the hearing form attached and tick the box written submission hearing to progress with this option. So in other words, if you want to plead guilty as a written submission and have them, say, oh, okay, we'll let you off because you're admitting guilt or whatever, yeah, chances are no, they want their fucking pound of flesh, they want their money. 3. Appear in court for a defended hearing. You can request a defended hearing if you believe you are not guilty. No. It's not a belief. You know for a fact that you're innocent. You're presumed that way. You can believe it. But they are the ones that have to prove you're guilty. Not if you believe you're not guilty. The hearing requires you to appear in court on the specified day. The court clerk will read out the defendant's names, and when your name is called, you will be asked to enter your plea. Well, let's just hope that the Auckland Transport can clearly and fully inform the alleged defendant of the cause and nature of the allegations towards them. Let's hope they can do their job properly so the defendant can enter a plea. Or will the JP just steamroll under section 41 and go ahead and enter a plea on your behalf, even though they haven't made sure that you've been fully informed first? Because they can only enter a plea if they're satisfied that you have been fully and fairly informed of the cause and nature beforehand. But then, judicial officers are immune from prosecution. Court security and court staff are immune from being prosecuted civilly for any offence. So they don't care how much they fuck up the paperwork. They're immune from it, so what do they care? Huh? Should you plead guilty, the matter will be finalised on the day. However, if you plead not guilty, don't mention special plea here, a defended hearing will be set for another date and you will be notified of the hearing date. Again, so the first time you go there is just a preliminary hearing. All they want is to enter a formal plea in regards to the matter. At that point, that's when you start asking to be fully and fairly informed of the cause and nature. And when they go, like Mike McMurtry did, what do you mean? What's cause and nature? Being a fucking legally trained expert, I would have thought they'd understand that lingo, but no. So they have to explain the cause and nature before you can enter the plea. Got it? Good. A defended hearing will be set for another date and you'll be notified of the hearing date. If you have any witnesses that you want to appear on your behalf, please make sure they are at court on the defended hearing day. Please note, only the person responsible for the infringement can enter a plea. Responsible, not liable. Okay? You have the ability to respond, i.e. responsible. Hearing requests must be sent to Auckland Transport by the due date for options 2 and 3, which are the sending in a written submission or pleading not guilty. Costs. If you plead guilty, option 2, and are found guilty, option 3 of the offence, the court may order you to pay fine and other court costs ordered by it. Because the court's an it. And then they give you all these wonderful numbers and they give you the account payee, you know. Don't forget to supply your bank account details just in case all those suckers want to pay straight away. Good on you, Auckland Transport. Well done. But as I say, I'll be ringing them up to asking them about email addresses and asking them if they've got white painted lines and yellow lines, which one sticks. Because if there's controversy, which there is in this case, I get to ask questions. And officer number 1126, I hope you're going to enjoy your day on the stand, mate, because by oh by, if this isn't withdrawn by the by Auckland Transport and I actually do get to go to court, I'm going to have so much fun with every staff member, every court security officer, every JP, every clerk, every single one of yous. You are going to regret ever running into me, because I'm not some stupid dumbed down fucking idiot that doesn't know what he's doing. I'm going there for fun. I have no fear whatsoever of you, so bear that in mind. I'm not making any threats. Oh, no. Wouldn't want to cause any disruption, but I do know what my rights are, I do know the process, and I will be asking step by step every fucking question I know to. So, cowardly little 1126 who went into the court building, spoke to the court security officers, and then came out and issued me that infringement, which I think is blatant retaliation, because the court security officers guys have probably said, go and give that cunt a ticket. He's been fucking recording us for a couple of weeks. We don't like him. I hope Chris has re-educated those staff too. I mean, that guy went back 6 days after Chris, you told me that you had the staff retrained about recording in public, and someone else showed up there on the 8th of October recording, and your little chihuahua came out and had a little barking session at him too. So either you didn't do what you said to me in the email, Chris, and you didn't make sure that their correct position was known to them, or it didn't stick. Either way, it needs to get fixed, and they better fucking have their badges on and displayed when I show up there, because I won't be listening to anybody posing as a court security officer unless they've got their identity out. Alright, it's that simple. I've supplied it in part 1, what section of the Court Security Act they must adhere to. Anyway, so that's the two options they give you. Now the fun bit. This is the letter that I sent to Auckland Transport Parking Review, to Private Bag 92260, Auckland 1142, on the 25th of October, the day after I received the parking ticket. And I find it somewhat curious that it took 12 days for me to get that parking ticket. So a week for processing, 3 days for postage. Should have still got it a couple of days earlier. But the fact that I get it 12 days, or nearly half the allotted time I have to respond back by the 28 days are up, they sort of cut your response time down by making sure you get it late. "25th of October 2018, to whom it may concern." We refer, now remember, they're talking to a you. A you is a plural, so don't say I. Don't say me or, anything referring to you as a single. It's we, us, our, because they're talking to a you. We refer to your correspondence in relation to an alleged stationary vehicle offence, infringement notice number 3066243825, which we received via post on the 24th of October 2016. I always do that to let them know it took them 12 days for me to get it. And it also shows that I only had 16 days out of the 28 to respond back. We accept this claim. Remember, you're staying in on it. We accept this claim by Auckland Transport against Mark Donald Eric Keane for value, provided that Auckland Transport can supply evidence of this alleged offence being committed allegedly by Mark Donald Eric Keane, evidence of Auckland Transport's jurisdiction, and evidence of Auckland Transport's authority. We believe Auckland Transport have made this allegation in error. Therefore, we formally elect and or request a court hearing to discuss this matter, to derive evidence of this allegation presumed against Mark Donald Eric Keane and gaining resolution. Should Auckland Transport choose to withdraw this allegation against Mark Donald Eric Keane without prejudice, no further action will be required. We note that the photographs associated with this allegation online included below do not show broken yellow lines. However, they do show the private motor car associated with registration plate FAN 394 and confirm the private motor car to be parked in a P90 parking area and parked in white painted parking spot, which we have returned and documented for any future proceedings regarding this matter. Furthermore, we note, as this allegation is a Schedule 1 criminal offence, that the onus probandi, or burden of proof, is for Auckland Transport to establish evidence of this allegation against Mark Donald Eric Keane, who is one of 2 registered owners of this private motor car, to the criminal standard of beyond reasonable doubt will be required. Mark Donald Eric Keane maintains a presumption of innocence in accordance with New Zealand Bill of Rights Act 1990 Section 25C. Please inform Mark Donald Eric Keane promptly and in detail of the cause and nature of this allegation, as to be fully and fairly informed of this charge to make a voluntary, knowing and willing plea. Initial disclosure in accordance with Section 12.1 of the Criminal Disclosure Act 2008 will be required by the set date for preliminary hearing. Because initial disclosure, you should have had that handed to you by the preliminary hearing, and full disclosure, or Section 13.1 of the Criminal Disclosure Act 2008, you should have that by the defended hearing date, which is set once a plea is entered from the preliminary hearing date. Notice: all correspondence will be recorded and published on multiple platforms for maximum accountability and transparency in accordance with New Zealand Bill of Rights Act 1990 Section 14, and notice failure to respond within 28 days shall constitute a tacit agreement that Auckland Transport have failed to establish evidence of claim, evidence of authority and evidence of jurisdiction with regards to this matter. Warmest regards, me. And I've attached the photo of the white parking spot around the car that I went back and recorded on the 24th. I've attached the 2 photos that I was able to see in relation to the infringement offence. When I went online, you can go and view the photographs, which are absolutely pathetic. And I would note they photographed that little sign above my registration tag there on the front left side of the windscreen. That little notice says that because they've issued me a ticket, it's going to cost them a $75 processing fee for me to do all of this. So after all's said and done, Auckland Transport are going to be getting a bill from me. So, but, you know, again, I'm not too worried about that, but seeing they chose to issue an infringement charge notice or a penalty charge notice against my private motor car, and it says it's a private motor conveyance in that little sticker that obviously he read being 10 metres away and filmed it, then if he's going to issue tickets, I guess that means you're liable because you've agreed to a tacit agreement that's notified clearly on the front and back of the vehicle. Thanks, Auckland Transport. I appreciate the $75 processing fee that you are now liable for. I've also supplied a couple of other photos of where that white car was parked, showing the back markings there of T parking spots, all showing that it's not just a yellow broken line, it's actually a car park space that hasn't been blanked out as yet. So that's my response. I'm actually going to make a generic version of this for anyone else that wants to challenge a ticket. Just got to fill in the blanks, fill in the dates, fill in the name, and everything else. But as far as if this helps someone else stand up for their rights and grow a backbone, by all means, have at it. I sent off to them on the 25th, which was 3 days ago. So we'll see. By the 12th of November, I expect to see a charging document in regards to a court hearing for a preliminary hearing if they don't withdraw straight away. I mean, honestly, if they withdrew it, it would bum me out. I wouldn't be able to go to court and have fun with that fucking parking warden for being such a scumfuck, for doing something as criminal, because he's making false allegations against me when he's not proven I did it. So, yeah, what a criminal. What a coward to sit back 10 metres and take a shot in the rain. There's not enough detail or information in those photos to show anything. There's a lot more detail in mine. So, bring it on, man. I am so looking forward to it. $60 parking ticket saga has only just begun. Their responses, or lack of, if there is any, will be in part 3. If not, in part 3 we'll be able to show you a court summons and a date. And by all means, it's a public court place, people. More the merrier. Come along, one and all. The guy that was filming outside, my friend from Discord that likes to have yak to me, come along, mate. Enjoy yourself. My other friend that followed the $80 speeding ticket, girl, if you want to show up, more the merrier. I know you said to me the other day you're looking forward to it and that you know I'm going to have fun with it. You betcha. More the merrier. Everybody come along. I'm probably expecting half the court security officers to be standing in the hearing too, just to keep an eye out and watch and see what goes on. Just for shits and giggles, when I do get the court summons, yes, I will be putting in an application or a submission or a please sir, may I record in the court building, because we all know what their court transcripts are like, and I'll be letting them know that I will also be requiring a written court transcript, not just notes made by the JP, because there'll be one JP standing there hearing it and there'll be another JP sitting there writing down his notes and asking me to slow down while I talk. Because yes, in today's day and age, they're still using written pen and paper notes and not a transcription service for Schedule 1 offences, even though they did in the last $80 ticket. So given that they gave me a transcript for every other hearing on the last time, I'm going to expect the same this time. If they say we don't do that, well, you did it last time, so don't bullshit me. Anyway, enough of my babble. Looking forward to it with bells and whistles. Chris, g'day mate. Like I say, all you court security officers, I know you're going to look forward to me coming in through your little jurisdiction. Best behave yourselves, okay? Because when I come into that place, you can bet it's not going to be alone, and you can bet I'm going to be having independent, impartial witnesses observing everything. So, till then, see ya. Got the remote, might as well turn it off with this. Bye.